And these are some of the rights that you're granted as a copyright holder, is to reproduce the copies of the work, derivatives of the work, to actually distribute the work, to perform the work publicly, to display the work. And there is a difference between actually owning the copyright in the work and owning a physical piece of work. So just because you own a painting does not give you the right to actually make a copy of that painting and sell that copy. You need to own the copyright in the painting to be able to do that. And the same goes for literature, artwork, photographs, videos, sound recordings. As I said before, copyright vests in the creator. So essentially, whoever puts pen to paper is the owner of the copyright, even if it's at the direction of someone else. So if you're ever hiring someone to help you with marketing, your website, blog posts, a videographer, you're going to want to ensure that you own all the copyrights in the work that they create for you. So what you should have is what's called a work for hire agreement. And it must be in writing and signed before they do any work for you. So if you're ever working with any independent contractors, always think work for hire agreement. Sometimes you'll work with graphic designers or other marketing people, and their agreements may or may not provide that you own the copyright. Graphic designers are one area that I've run into a lot, where I believe it's the Graphic Design Guild, is very much that they create the work and essentially license it to you for that specific purpose. So if you ever want to change it, you have to go back to that same graphic designer that originally created it for you, because you only had a license to use what they created. So be very cautious when you're working with any third parties for anything for your website, marketing material, branding, videos, audios, if you're doing podcasting. Ensure that you own all the rights in the copyright to the work that's being created. As I said before, ownership of the physical work is not ownership over the copyright. So you need to ensure that you own the copyright in order to make copies of it or create derivative works of it. And you might hear the word license or assignment. Essentially, a license is, think of it as a lease to a piece of property. You get the right to use it so long as you're paying rent, whereas an assignment is a transfer of ownership. It's more like purchasing a piece of property, that you get to use it free and clear of the others, and you can actually sell it to someone else afterwards. Something that has come up a lot is, especially when a client is hiring someone to work on their website, you want to make sure that in the contract with them that they're only going to use pieces of work, whether it's photos, videos, that they cleared the rights to, meaning that they have the rights to use them. Because what I see a lot, and you might have heard of, is people using photos from the internet. Just because you find it on Google, it does not make it free. Someone still owns the underlying copyright in that photo. And what was happening was a lot of web designers were just taking photos. Sometimes even the web owners themselves were taking photos from Google Photos and just putting it on their website. And then a couple of years later, they'd get a cease and desist letter demanding an outrageous sum of money because they used this one photo on a blog post 4 years ago. So you want to make sure that whoever is doing your website, whoever is picking photos, videos, anything to go on your website, that they clear the rights to that. And you can put that in your contracts with them, that they will only use works that they have cleared the rights to. And if not, that they will indemnify you so that if you do receive a cease and desist letter, they'll be the ones that have to take care of it and pay whatever the damages are.